Well, good afternoon. Thank you very much for coming along and for tuning in to the first session of the Glasgow Forum for Scots Law. The theme this year for our forum is private law and public policy. We thought we would pick up on this theme because it was something that reoccurred in our discussions last year. We're continually returning to discuss how government policy was starting to impact upon areas of private law and in areas of particularly legislation which were being codified or trying to change particular areas of private law. And when John and I came to discuss things, we saw that this is happening at an EU level, it's happening at a UK level, and it's happening at a Scottish level. So we thought we would have a series of seminars on this and workshops, and we're very pleased that Halle is here to give the first one. Halle Turner is a third-year PhD student here in the University of Glasgow, and Halle's doing some really interesting research into party litigants within the Scottish court system, particularly sheriff courts, and Halle's spent a lot of time in the sheriff court, observing courts, but also speaking to those working within the courts and also speaking to sheriffs. And one of the things I think that has been noted is lay representatives turning up in the sheriff court. And it's interesting because a few years ago Hazel Genn gave a lecture here in the University of Glasgow, and one of the things that she noted was the significant increase of Mackenzie Friends or lay representatives within the English courts, and she expressed deep concern about this because it was unregulated and because the courts were unsure as to how to deal with them, and so she was very keen for there to be some government action in this area. So against that backdrop, we're very pleased to have Halle here, and I will hand over to Halle. But just before doing that, I'll say if you are watching online, you're welcome to tweet questions to the Glasgow Forum for Scots Law. If you look for us on Twitter, you can tweet some questions. So, okay, don't make them too hard. Okay.
Clea, thank you. What I wanted to talk about today is to look at lay representation as a topic really of increasing interest in Scotland against the backdrop of civil court reform that has been ongoing, looking particularly at the issues around access to justice, the big questions, access to the courts, public policy, and also looking a little bit at some of the food for thought that lay representation can give us about legal education and training, the regulation of the legal profession, and then what I'll really focus on a little bit more is questions about implementation of these sorts of public policy initiatives around rules of court and changing court procedures and opening up access to lay people within the courts. So to start off with, just in case anyone's not familiar with lay representation, a lay representative is really defined by what they are not, which is they are not a solicitor or an advocate or someone who is otherwise legally qualified, representing someone who is what we call a party litigant in Scots law, someone who doesn't have a solicitor and is unrepresented in the court. So you can see from here that lay representatives are really drawn from quite a broad spectrum of training and experience. Everything from what I'm going to call a career lay representative who might be work for something like Citizens Advice or Shelter, all the way down to someone who might be just a friend or a family member of the litigant who may or may not know any more about the law than the litigant does themselves. And what you would say, obviously, when you hear that they don't know any more about the law than the litigant themselves is, well, what's the point? So I wanted to pause just for a second on that point to discuss what I'm going to call the capacity gap that we have in Scottish lay representation. And what I mean by that is the idea that anyone can self-represent, and if they don't have access to a lawyer, will really be required to self-represent if they have legal capacity. And we're all presumed to have legal capacity and presumed to be sane. But that's a really low bar. And people can very easily have legal capacity but not have what I'm going to call functional capacity, by which I mean they might not be able to read or write, or they might not be able to speak English very well, or they might be disabled. And in my court experience, court observation experience, what I have seen is very often when you do see these friends or family members acting as lay representatives, it is for someone who has some sort of functional capacity issue, like an adult parent, an adult child representing a disabled parent who just can't make it to court, or someone who is illiterate, or someone who, again, needs a translator or even a carer appearing for someone. So that's really where these one-off lay representatives, they can have a role to play, but obviously it's not really an ideal answer, and ideally those people should have lawyers and access to really qualified legal advice. And finally, non-natural legal persons like companies or partnerships in Scots law cannot self-represent. They can't be considered party litigants. They can only have lay representatives. So for the most part, when we're talking about lay representation, we're talking about lay representatives for individuals, because historically very, very limited access to lay representation has been allowed for non-natural legal persons, and only in the small claim summary cause, what we call the low-value claims. But just literally last week, they've published new rules that's going to widen access for companies and partnerships to have lay representation. So I'll talk about that just a little bit more in a minute. So what I'd like to do now is set out a little bit of the legal framework around lay representation. And maybe the really most important point to make is that the default position in Scots law, and historically has been, that only a solicitor or an advocate can represent someone in court, or they can represent themselves. And the history of lay representation in Scotland is really measured in decades rather than the centuries that the courts have been around. It's just not been a part of the Scottish courts until very recently. So whenever you do have a lay representative appearing, they have to appear under one of these rules or provisions that I'm just about to discuss. And that's something that lay people are not usually aware of. They don't understand that they can't just come to court and speak for their friend or represent their friend. So just to talk through these various forms of lay representation, and if it seems really confusing as I'm going through it, it's because it is really confusing, and it's known to be a really confusing area of law. It's been done really sort of piecemeal, and it's a really kind of untidy area of law. So if it seems confusing as I'm going through it, it's really well known to be confusing. So the first form that I'm going to discuss is what I'm going to call statutory lay representation. And that is provisions that you find in certain legislation that allows someone to have a lay representative in a certain type of action. So these are things like sequestration, some forms of diligence, recovery of heritable property. And under these provisions, the lay representative can do anything the litigant can do for themselves, and they don't need the court's permission to act, but they can be removed if they're found to be unsuitable. These types of actions what's interesting about this is that these sequestrations, diligence, they're not court actions in the way that we traditionally think of them as sort of dispute resolution. They're really more legal procedures. Sequestration is really a form of diligence, so that these types of actions are really very narrow in scope, and you're not going to usually have even things like written pleadings or leading of evidence. Even the sheriff's discretion usually is quite narrow in these cases. So these are types of cases that really using a solicitor in a lot of cases is going to be using a hammer to crack a nut. Even if the person could afford a solicitor, really what they just need is a little bit of advice and a little bit of help guiding them through the process. So in a lot of cases, a lay representative is really appropriate to use in these cases, and these statutory provisions are really intended for career lay representatives to be able to assist people, like, for example, people from shelter and housing cases. So looking next at the simple procedure, this is coming into force actually next month, and it's replacing the small claim summary cause procedure that we used to have for actions under £5,000. And again, the lay representative here can do anything the litigant can do for himself. They don't need to get permission per se to act, but they are asked to lodge a form with the court before they begin acting. So we have yet another form that we have is what I'm calling the rules form of lay representation. And this was introduced in 2013 as a sort of blanket provision inserted into all the rules of civil procedure in the Scottish courts. So now in pretty much any other form of action, an unrepresented litigant can apply to the court to have a lay representative make oral submissions on their behalf, but the litigant has to be present as well, at least in principle. And the They have to lodge a form with the court, and the judge should only grant the application if they are of the opinion that the lay representative can assist with their consideration of the cause. Then these new rules that we have coming in November, that again, they were just published last week, will allow someone like a company director, someone who holds a relevant office, to represent a non-natural legal person in court. They have to show that they're authorized, again, lodge a form. And what's really interesting about these rules is they also have to demonstrate to the court that they are unable to pay for legal representation. So that's going to be quite interesting, I think, to see how that sort of test is going to be applied and how often those applications are going to be granted. And finally, the courts retain the inherent power to grant or refuse a right of audience as they see fit. But that's really very rarely used, and courts have been really clear that they consider that any sort of extension of rights of audience should be done by statute. It shouldn't be done sort of as and when the court sees fit. So just to run through now a few other relevant features of Scottish lay representation. In England and Wales, they do have paid lay representatives and lay assistants. Under certain circumstances, in the Scottish courts, we just don't have paid lay representation. The rules either forbid it or they're silent, but it's just not a part of our legal landscape here the way it is down south. You can't recover any expenses incurred in the course of having lay representation in the cause. There's no sort of external regulation or qualification for lay representatives in Scotland, as well as in England and Wales. There's no regulation or qualification for them there as well. And as a result of that, all the rules that we've just discussed, they all apply equally to what we call your more experienced career lay representatives and to your one-off lay representatives, because there really is no way in law to distinguish between them. So in the eyes of the law, really, they're all the same. So what we've discussed now, hopefully, is setting out what we know about lay representation in Scotland. And what I'd like to now move on to discussing is just some ideas about what we don't know about lay representation in Scotland. And what I'd really like to suggest is that as this is a really relatively new idea in Scots law, it's not native to Scots law. In fact, it's been really kept out of Scots law for quite a long time. The implementation of what this seems to be a really simple public policy idea of let's expand lay representation and access to lay representation in courts is actually maybe a bit more complicated in practice. Because the Scottish courts are a very highly regulated environment, the rules are very prescriptive, and they are very adversarial. And for purposes of this discussion, what's important about the fact that they're adversarial is that the proper function of the court really relies on everyone within the process knowing their role, knowing their relationship to everybody else, knowing the law, knowing the procedures. You can obviously see how entering lay people into the process who obviously don't know all those things can really throw a spanner in the works. And in the absence of further provision in the rules, we don't really have any case law. And what I'm going to suggest is a lack of linking up with lay representation with the sort of wider legal landscape can create some difficulties in understanding and implementing lay representation. So to start out with, to sort of try to start demonstrating that point, what I've listed here, and I don't know that this is exhaustive, but all of the various areas of law that govern and inform and help us understand the role of a solicitor. And similarly, we understand that a party litigant is a party to the cause they're involved in, and that has meaning in law, and that infers sort of certain rights and responsibilities, and really we know what the stakes are for them. When we talk about lay representatives, obviously a lot of these things don't apply. A lot of them are question marks. And what I really would like to suggest and sort of unpack is the idea that all of these things listed up here that apply to solicitors and litigants, these are really the things that provide predictability to the function of the process and that provide consistency and give judges the tools that they need to make decisions and answer questions as and when they come up in the civil courts. And I think this is particularly important to this discussion because when we're talking about lay people engaging directly in the process, you're going to see more questions than you're going to see when you have solicitors. Going back to the previous point about we have seen the variability of lay representatives and their experience, similarly with party litigants, wide variety of experiences, capabilities. We have lots of different procedures in Scots law, just sort of endless circumstances that are coming up. And what I'm hoping to get across is kind of looking a little bit more closely at some different areas of law and some different questions, is the extent to which we really need that legal underpinning in order to implement lay representation a bit better and to answer those questions as and when they come up. So to start out with, I didn't want to dwell on the procedural uncertainties around lay representation, and there are a few because I think everybody but me finds procedure really boring. So I'm just going to highlight one, which is, I think, quite a fundamental one. When you're making an application under the rules form of lay representation, it's not clear whether the lay representative can address the judge on the application because they don't have a pre-existing right of audience. In cases I've observed, sometimes they are allowed, sometimes they aren't. And I think that's a pretty fundamental question, and these are questions that are usually really easily and readily answered in the rules. And again, you can kind of see coming back to these capability questions, what if the litigant does have this sort of fundamental capacity issue and they're not able to communicate what they want to get across to the sheriff, all these sorts of issues. Again, I think that's just highlighting sort of one example of a procedural uncertainty arising in lay representation, and there are a few more. And then coming to this next question, which I think is really the big question about lay representation, is what precisely is the relationship between the lay representative and the litigant? And it's something I've thought about a lot and had a lot of difficulty with. And I think part of the reason I had difficulty with it is because our terminology has gotten a bit muddled, and we refer to a solicitor as a representative, a representation. We also refer to them as an agent. I would suggest that when we're talking about the rules form of lay representation, where they're only allowed to make oral submissions, that truly is in law a representative. When we're talking about the forms where they're able to do anything the litigant can do for himself, particularly when the litigant is present, I think we have to regard that as some sort of form of relationship of agency. They are doing things that have binding legal effect on the litigant. I've mentioned mandate there because I don't think that's really something that's relevant in Scots law anymore, but that is what we used to refer to as the gratuitous form of agency, and lay representation is, by its nature, at least intended to be gratuitous. And in a sense, what we're talking about actually almost fits better with these very old law discussions about mandate, but I say it's not really relevant in Scots law today because particularly when we're talking about somebody carrying out duties that require the level of expertise that representing someone in court does, and where the stakes are so high, people just don't do that gratuitously anymore. And so it's really difficult to understand somebody carrying out those sorts of duties gratuitously. So coming back again to this question of, is the lay representative an agent? Again, I think in practice, at least, quite often they are. There is some sort of relationship of agency there. Then we have to start asking ourselves, what are the parameters of their authority? Do they have, can they only act on express authority? Do they have implied authority? Because a lot of what solicitors do has to operate within implied authority. Sometimes they have to make, for example, when they're in court, they have to make decisions. They might not be able to act exactly on their instructions. Can a lay representative do that? Can they only act on their express instructions? Again, do they have implied authority? Do they have apparent authority? All these other sort of questions, I think, we don't really have good answers for looking at lay representation. And that feeds into this next question of what happens when things go wrong. And I don't want to suggest that things will always go wrong or particularly go wrong with lay representatives, but I think in law we always want to know, have a level of ability to predict what will happen when things go wrong and know what will happen when things go wrong. So I have a little scenario to try to demonstrate maybe some of the issues. If you have a case where you have a solicitor who settles the action with the opposing party, disposes of the case, and that's something that happens in the civil courts probably every day. And then later, the litigant says, well, no, I didn't instruct you to settle the case. I'm not happy with that. And again, that's something that has happened. What we know, going back to the previous slide with all these areas of law that inform what we know about the solicitor, what we know is that in all likelihood, the opponent is going to be able to rely on the solicitor's apparent authority and rely on the settlement. And we know that the litigant may very well be bound by the settlement. And again, that's something that has happened in the courts. What we further know is that the solicitor, if he's not acted on his instructions, that's contrary to the law of agency. He may very well be in breach of contract with the litigant. he may be liable in professional negligence, and we further know to what standard he should be held because we understand that in the law of negligence. We know that he may be subject to professional discipline. We know all these things because of all these areas of law. What we don't know, if we take that same scenario again but pop in a lay representative, even the first question becomes difficult to answer. And I would say that it's not a settled point of law. Can they rely on the lay representative's authority in settling the case? It would probably very well depend on the type of action and the form of lay representation they're appearing under. Then coming to the next question, what recourse would the litigant have if they are bound by the settlement? Again, that's really difficult to answer. None of these, again, it's not a settled point of law. None of these areas of law that we've discussed necessarily apply. And I think that's a little bit problematic because, again, turning to all these sort of questions of what could go wrong, if you have a litigant who just, or a lay representative who just doesn't turn up for court and the litigant could have decree passed against them. If they're just simply out of their depth. And that's, again, that's a case that I've observed where there was a lay representative who made a legal argument and was out of their depth and was cautioned by the judge that they were out of their depth and was unsuccessful and ended up running up further expense, basically, for that the litigant was then liable for protracting the proceedings, which solicitors make arguments that are not successful all the time, and that's fair enough. But when we're talking about a lay representative, the difficulty there is that, unlike a solicitor, the court isn't able to rely on the knowledge that the litigant was informed of the risks, that the lay representative was qualified to make the argument, and again, that the litigant was able to give informed consent and properly instruct the solicitor. With the lay representative, we don't necessarily know that. So that sort of demonstrates some of the assumptions that underlie the office of solicitor that don't necessarily underlie the office of lay representative, and which I think can result, it's perhaps a bit contrary to the public policy we're trying to implement if the litigants who can't afford a solicitor and have to use a lay representative who may already be a bit more vulnerable are actually left sort of at their peril with the lay representative and left without any kind of recourse. And so just looking at a few more things really quickly, in England and Wales, because they have a lot more lay representation, because with changes to their legal aid system, they have a lot more unrepresented litigants, and so we're seeing the case law there developing a lot faster than it possibly could here. And we've seen a little small but growing body of law around banning orders being granted against lay assistants or lay representatives who are, I don't want to necessarily say vexatious because that's sort of a term that has meaning in law, but problem lay representatives who they've had to stop from acting basically because they're causing problems because of issues with their conduct. And that's not something that's happened here yet, and I don't think that it necessarily is something that could occur frequently, but I think that it can and does happen. And I think that the Scottish courts should hopefully have the tools to deal with that as and when it comes up. Referring back to the English example, these banning orders are granted under the court's inherent power, which strictly speaking are powers that the Scottish courts have acknowledged that they have, but that I think that, going back to what I was discussing earlier, the Scottish courts don't like to use their inherent powers, and I think they maybe would be pretty hesitant to grant that sort of banning order against a rogue lay representative. When the rest of the Courts Reform Act is implemented, we'll have what are called vexatious behavior orders, which are really analogous to these inherent powers, but being given sort of form in the statute and in the rules. So again, that would probably apply and be able to be granted against a problem lay representative, but again, it's something that's really untested in Scots law. I would say that, again, coming back to my experience in sort of court observation, that was the thing that really struck me more than anything, was how potentially powerful a lay representative can be when a litigant has been told no by solicitors, been told they don't have a case, they don't have any recourse, probably quite correctly because they don't. But then if a lay representative comes along and says, oh, well, I can help you, giving people hope, or a lot of times the lay representative might be seen to be speaking their language or be speaking common sense in a way that the lawyers in the court aren't, and there can maybe be even a little bit of an us against them mentality. And so it can be really powerful, and you wouldn't want to see people getting sort of led down a path of incurring expense for themselves, incurring expenses for the other side on a meritless action. And again, I don't think that's something that happens often, but it is something that can and does happen. Can and does happen. And finally, just looking at non-natural persons again, with the implementation of these new rules, we're going to see the potential, at least, for lay representation for companies in actions of considerably higher stakes than what we've seen before. And I think I can see a potential there for some issues arising in company law and partnership law as and when that's implemented. And again, another really interesting feature of these rules is that unlike all these other rules for lay representation for individuals, these rules allow that if the lay representative's conduct, if there's some sort of conduct issue with the lay representative, they can be found jointly and severally liable with the company in the expenses of the action, which I think is really interesting, and I wouldn't characterize it as piercing the corporate veil, but as giving it maybe a little bit of a poke in the way that I don't think that we've seen before. And so I think that's going to be really interesting to see that implemented. So finally, I'll just go through really quickly, having identified, I hope, maybe some issues in Scottish lay representation, to just go through some suggestions that have been made or suggestions that have been made in other jurisdictions. Judicial training, you see quite a few calls for judicial training, particularly from career lay representatives, although I think that's typically more in an effort to create more of a lay representative friendly environment, more so than to deal with any of these sort of legal issues that we've discussed. In England and Wales, we mentioned they have a practice note that fleshes out the role of the lay representative and the procedures a bit more, although currently they've proposed introducing rules that, if you read them, look very much like the rules that we have. So I'm slightly skeptical about, I think that rules can accomplish a lot, but as I said, I think that rules can't really ever account for all the possibilities in the courts, and I think that that's why the sort of legal underpinning and understanding is really important. Another proposal in England and Wales at the moment is plain language guidance, which I think is something that's overdue both there and here. So the rules of court we have now are really intended for judges and lawyers to read them, but clearly we really want lay representatives and party litigants to be able to understand exactly how lay representation works and know what they're getting into, really, when they enter into it. And then finally, regulation. Again, that's a really perennial question both here and down south. A lot of career lay representatives want regulation because they want to be recognized over and above, as we've discussed, just sort of a one-off lay representative or somebody who doesn't know what they're doing. In Scotland, I think cost is a particular issue because in England and Wales, the discussion as well, presumably that cost is passed along to the consumer. Here, where does the cost come from if lay representatives can't be paid? And I think that the cost-benefit analysis, I think, is not necessarily there for regulating lay representatives, because I don't think that it would necessarily accomplish enough over and above what the exercise of judicial discretion and judicial oversight could accomplish. And so that is everything, and thank you very much for your attention.
Thank you very much.
Thank you. I don't take over time.
No,
okay,
not at all. No.
Okay, good.
You could have spoken for longer.
Okay, cool.
And you just said something really interesting there at the end, which I'm furiously writing down. But do we have any questions from those of us here in the room? There are actually quite a few people down this end of the room, but they didn't want to be on television.
I've got loads of questions. I thought that was really interesting. Thanks very much. I was in practice for a few years before I came to do my PhD at the university, and it was civil litigation that I worked in, so I had a lot of experience of being a kind of trainee in what was a small claims assembly called court at the time, and seeing a lot of this stuff in practice, either with party litigants or with lay representatives, whether kind of career lay representatives, like you say, or just someone's friend that's come along to kind of help them out. And it is a very difficult world, I think, for all sorts of different reasons. But I was just quite interested. I thought it was really interesting that your paper was happening today, because there does seem to be a bit of flurry of activity about Mackenzie Friends in England at the moment, and this sort of increasing professionalisation-ish after a fashion of Mackenzie Friends down south. So now there's there's like a sort of association or society of Mackenzie Friends or something, and there's a website you can go on, and there's all these people who are registered to be Mackenzie Friends in England. But there seems to be a problem there, that there's a bit of scamming going on, or that seems to be the concern down there, is that people are putting themselves forward as being in some way qualified to act as a Mackenzie friend, and then charging money to people who think, oh, I can't afford a lawyer or a qualified solicitor, but I can afford to pay this person, you know, £200 a day rather than £350 a day, but what they're getting for their money is just some, you know, con artist or someone who's just not really very good at it. But I sort of feel like a lot of the solutions that they're starting to come out with in England, or the concerns that they have in England, are not really the same. I feel like the problem that we have in Scotland is much more, it is your pal or, you know, the adult child of a disabled parent or something who isn't doing a good job because of, as you described it, the kind of functional capacity gap. So I feel like, I don't know if you think this is fair to say, but like our efforts in Scotland should be more concentrated towards not so much regulation or liability for lay representatives, but some kind of way of making the process easier, so plain language, guidance and support through the process. I mean, maybe those two things don't have to, maybe they could both happen. But I just wondered if you kind of feel like if you're making recommendations for reform, it's the supportive stuff that we need to be focusing on in Scotland rather than the regulatory side of things.
Yeah, it's really tricky, and that's why I think the issue of payment is such a big one, and that's why we can't really readily compare England and Wales to Scotland, because that is kind of the elephant in the room, that they can be paid and it's becoming a profession there. I think you mentioned the scamming people. They actually had somebody who I think went to jail because they held themselves out as a Mackenzie friend and took a lot of money and was literally doing nothing. It was just a complete fraud. And that is tricky. And then, as you say, you do have people, it is this problem of, because there is no regulation and people are being paid, what are their qualifications? How can people really know what they're getting into? And the other problem they have in England and Wales, particularly with payment, is that a lay representative can't be paid until they've been authorized by the court to appear. So they would literally have to come along to court and ask to appear, and they won't even know until on the day whether they are entitled to appear, and therefore whether they can be paid, all this sort of thing. Yeah. So payment really complicates things. And as you say, yeah, it is tricky. I agree about support. The problem, this is the thing that I think about a lot, just sort of in my project in general, on party litigants and these questions of how can they be supported, to what extent should they be supported. It's difficult. I think plain language guidance is a really good idea, but then the thing I always think about plain language is that it's necessary, but it's not sufficient, because you can put things in really simple terms, but the courts are still really complicated, and the law is still really complicated. And I think it really does depend, again, on what sort of case the person's involved in. A typical ordinary action, I think that really anyone who's not a solicitor is going to really, really struggle to lodge written pleadings. And the thing that comes up over and over again in the interviews that I've done is that giving and taking of evidence is where so many people run into such massive problems. And I have questions really about whether even career lay representatives are able to do that effectively. And that's why I say, referring to those statutory types of action, that's really where they have the role to play, more so than these other forms of action. Because frankly, a lot of judges say that a lot of solicitors really struggle with, giving submissions, taking evidence, all that sort of thing. So yeah, it's really difficult questions to answer. And one of the things that I have kind of thought a lot about, again, both in these questions of lay representatives and party litigants, is the extent to which it is better to leave things to judicial discretion as opposed to really codifying the process and really giving a lot more information out. I think really fundamentally one of the problems that we have in Scotland in particular is that, and this is maybe going to sound a bit strange, but it's not really anyone's responsibility to inform party litigants about the court process. It's not really the Scottish Court Service's job. It's not the opponent's job. It's not really the judge's job. And so whose job is it to produce this information and to make sure they know what they're doing? It's not really anybody's. I think that's one of really the fundamental problems. I hope that has answered your question.
Yeah. I don't want to monopolize the conversation, but I think you're right that kind of lack of understanding of whose job it is to provide that guidance is definitely a part of the problem. And I've seen that so often in court with lay representatives or with party litigants especially, where you can see that the party litigant doesn't really understand what what they're supposed to be doing procedurally, or what maybe they're supposed to be arguing legally. Like they feel they've been, an unfairness has been done to them in some way, but to be able to break that down to what, legally speaking, is the right that has been breached here or whatever, that is something that's very difficult for them to understand. Like sometimes I think, like to a certain extent, plain language guidance of how the court works is definitely something that would be useful, but the law itself can't all be broken down probably into plain language, or we wouldn't have to spend 4 or 5 years training students to be lawyers. So it is a difficult thing, but yeah, I think that responsibility question is an important one. I also think, though, that could be great from the perspective of someone writing a PhD on this topic, because you could write the guidance. Think of the impact that would be.
I know, it's true. Something that's really struck me quite often is there are these big questions, things that are really difficult to communicate to party litigants and really difficult to produce information on, but then there's some things that are really simple. Like they turn up to an options hearing and think they're going to argue their case.
Yeah.
And there's literally nothing in the documentation. The court's given them everything. Well, of course they thought that. How could they know what an options hearing is? How could they know what sort of motion they're going to be asked to make? And those sorts of things seems like they might have really simple solutions if and when someone takes responsibility for it or is asked to take responsibility for it, I guess.
Yeah, agreed.
Any other questions? Tom?
Yeah, one of the things that struck me when I was listening to your presentation, and you can tell me if you agree or disagree, it seemed as if there's more of it going on in Scotland. There is a sort of governmental view that lay representation has its uses and should be facilitated to some degree, but that's really as far as we've got. And nobody in government has really asked and answered the question, how much do we want to rely on representation? What can we reasonably expect of lay representatives? What are the implications of that for regulation of them? And if none of those questions have been answered, then all the specific rules that don't really make a lot of sense.
I know, I sometimes think one thing that's happening is we are seeing a lot of influence from England and Wales because it's becoming such a big issue, and we can't help but notice it here. And it could seem a bit, well, why can they do that here, but we can't, why can they do there, we can't do that here. I do sometimes have an inkling that I sort of wonder if there is almost a hesitance that the more we acknowledge party litigants, particularly in these procedures like ordinary cause that are not really intended for them, the more we acknowledge lay representatives, is it going to attract them? Is it going to make for more party litigants if we make the system simple for them, if we make it easier for lay representatives to appear? And so if maybe there's a bit of hesitance there and so it's sort of like, well, we're going to sort of throw this out there and see whatever the uptake is, but we're not going to go too far to making it easy or defining it or really making up. The sort of big question really is the intention that this lay is this role meant to be a quasi sort of solicitor, which I think a lot of people think, well, what's the point of having solicitors if we're going to let lay representatives? Why do you train for 5, 6, 7 years if somebody else can just do the same job? And those, I think, are the big questions that haven't really been answered yet, that we haven't really, in even sort of a public policy sense, I don't think that we've really sort of come down one way or another on that just yet.
We've had a question on Twitter from the Scottish University Law Clinic network. And obviously there's a lot of law clinics now in Scotland, in Strathclyde and Aberdeen. I think we also do some in Edinburgh as well. And I suppose the question is this, in 140 characters, are there specific issues for student law clinics? Because and it did occur to me how we were looking at this, sort of almost thinking of maybe an individual who's a lay representative, or something like what Frankie mentioned down south, some sort of website where you go and find a Mackenzie friend. But what about in Scotland? Have you got any thoughts about the law clinics?
Yes. What's interesting is, again, it has come back to the sort of question of the sort of blanket nature of the rules, and that everything applies equally to everyone, and there's not really any sort of differentiation for student law clinics. But the thing about student law clinics, at least as I understand it, is typically they're quite well supervised, and really usually there is a lawyer behind the student sort of keeping them right, if that makes sense. So they're coming from a point of a bit more expertise, or at least they have that sort of protection of knowing that they have someone legally qualified, making sure that everything sort of keeps going the way it should. What I think is really interesting about lay representation and in the context of student law clinics is how it's kind of developing alongside this increasing interest that we're seeing in clinical law education in general, and moving away from, at least in some places, moving away from the traditional sort of black letter reading, taking exams, all that sort of thing, to putting students out into the environment sooner. And I think, yeah, that definitely can have a lot of benefit, and it can have a lot of benefit for unrepresented litigants to get assistance. And the more that grows, I think that would certainly, particularly, again, the complexity of the action is going to be relevant. I don't think the students might really struggle to take on these more complex actions that party litigants might be involved in. But again, for these sort of lower level actions, you could see a lot of increased provision for lay representation and really effective, experienced lay representation coming from student law clinics.
Mm-hmm. And just a comment back on that, I think some of the problems that may arise with lay representatives are addressed with student law clinics. One is giving people false hope, because law clinics
wouldn't do
that.
Yeah.
From my involvement when I was a student, that's one of the clear things, is you've got to assess the merits of the case, but also from the point of view of motivation. I think it's quite clear what the law clinics are doing. It's a sort of civic thing, but it's also a learning thing, but it's also got a contribution back to society. So it seems a good solution there. But my mind does always go to liability issues, because it does become more complex if there were to be a problem about the liability of, is it the student, or is it the law clinic, is it the university? Now I think actually, in fairness, in Scotland, the universities who are involved in this have done a bit of thinking about it. But I wonder if that came on your sort of horizon when you were thinking about the sort of complex legal background to liability for expenses and such like.
Yeah, I think that would be a lot less, as you say, I think it would be a lot less likely to become an issue because of that issue of supervision. I think where that really kicks in is not letting students bite off more than they can chew, and making sure that they're staying within their capability and they're not going. And again, it's just, I think, in those circumstances, I think it's just really giving the litigant, they're just able to get a little bit of advice and get sort of guided through the process. But I don't think that those that typically take on, again, these kind of actions that, as I understand it, they're typically not drafting a writ and conducting a proof. It's more these kind of lower level things that lay representatives can really do effectively. And that is one of the issues, again, with even career lay representatives, is they're really self-regulating the complexity of the actions that they can take on. And I don't think that is, again, as much of an issue in student law clinics, because they're supervised and they're going to tell them, well, no, you can't do that. But even people who work for Citizens Advice or Shelter, and they have provision, the provision in what they do really varies, as I understand it, throughout the country, depending on who's there and what they can do. But there's not really anything, again, to stop them from maybe biting off more they can chew necessarily. Or I think that usually they would be sensible enough not to do that, and they know not to do that, but there's not really anything to stop them doing that. And sometimes they might get a bit overzealous and maybe take on something that is a bit over and above what they're able to do. Not often, though, certainly.
Any other questions, Bernadette?
I was just going to say thank you. That was really interesting. I really enjoyed it. Just from a sort of general point, I do fully support the idea that you should get some plain language guidance. You should do anything you can to try and make the whole court process simpler for anybody. Because even in the research project that I'm doing, when people, the solicitors that I was talking to, were asked, what advice would you give a client if they came and they wanted to pursue enforcement action, it was really, don't bother, because it's too expensive and too complicated and whatever, and the outcome's uncertain. So I think that there is a perception that in general the whole court process is difficult and complex and certainly expensive. And I do certainly support the idea that for lay representatives that they should get some judicial training, but of course that costs money, and where's the money going to come from that? So it's all very well, having this public policy that you say, yes, we are going to support lay representatives, but from whatever level, that's going to cost money. And it occurred to me then, well, why should the lay representatives get the training? If I'm a party litigant, should I not have access to that as well? If I won't, why should it just be for a lay representative? And then maybe does that lead to a two-tier system where you have solicitors who are at one level because we've had all the studying and training qualifications, so do you get a two-tier level of justice? And I know that probably civil legal aid is kind of a long forgotten ideal now, but you know, I think it would be a pity to commit to something unless there is the money there to put into it, and that would give people false hope. And perhaps there are other ways of approaching it and looking at it to see if something can be done. And because just in general, I was talking to a while ago someone from Edinburgh University who was involved in training sheriffs. And you know, it's not just the litigants and the solicitors who maybe have trouble with the court procedure and you know and what they can do and what the legal position is, because you know the people that are sitting on the bench need to training as well. And again, that's more money. So I think unless you know quite a lot of money is invested in our court system, then we're not going to get to where we want to get to. And maybe it's a little bit too ambitious to try and think that you're going to solve all these problems, you know, in a short period of time. But, you know, when you talked about the career lay representatives, presumably people from shelter, I don't know about the law clinics because I've not had too much involvement with them, but people from shelter, they have some kind of contract that they enter into with the litigant, or something that they have to sign up to that says that they'll do this and that and whatever, and if they don't do it, then the systems advisor, whoever it is, they can withdraw from acting for them. But I must admit, I'm personally, just a personal opinion, I'm kind of opposed to the idea of paid lay representatives, you know. But I can see that it's a good thing to have the lay representatives there, even for someone who it might not be a disability. It might just be somebody that's not confident in getting up and speaking in in any kind of public situation, but far less when it's in a courtroom and there's somebody sitting on the bench with a wig and frowning at them, and they just feel intimidated by the process that they're in. And they're just not very articulate. They could sit and write something out, but they can't stand up and talk on their feet. So I do certainly support the lay representatives, but it's a very difficult question about what can be done to support them unless there's something to use money.
That is the big question. I think a little bit cynically, sometimes it does kind of strike me that we kind of put the rules in place for lay representatives, and that's a way to sort of be seen to be doing something about access to justice without actually spending any money on it directly. And I think, I agree. I think that the question of, I have the same kind of natural disinclination to want to see paid lay representatives in Scotland, and I couldn't even entirely say precisely why. And I would certainly think that, going back to sort of what I was discussing in the presentation, to introduce paid lay representation in the landscape just as it exists now, I think would be a very bad thing. I think that we'd need to really understand it a lot better or regulate it or something like that. What's really interesting is I was talking a bit about the consultation they're doing in England, or I think it's close now, but one of the things they were consulting on is, should we no longer let lay representatives be paid? And I don't know that they've issued a report on that yet. The last thing I've seen is the consultation had closed. And actually, barring payment for lay representatives had gotten quite a lot of opposition actually down there. So again, we'll see what they do with that. That again would be really interesting to see. I have an inkling that I don't think that they are going to make that change, but we'll see what happens.
Because I can, again, on that, I can see opposition from solicitors saying, well, lay representatives then, if they're being paid, need to be regulated, and should they be regulated as highly as solicitors are regulated? Because you mentioned the Scottish Legal Complaints Commission was the discipline tribunal as well, and then possibly personal responsibility as well.
Yeah, it seems really perverse in a way that the people who are really qualified and experienced, who are less likely to, at least in theory, make a mistake, have all this regulation and you have all this recourse, and then the people who you don't really know what you're getting into potentially. That again, there aren't really any stakes for them or recourse for them. That is, I think, the big issue there.
Any other question? No. One of the things that I was going to ask about is judicial discretion, because these days generally people are like, oh, judicial discretion, that's not a good thing. We shouldn't have too much of that. We shouldn't give a judge too much latitude because he or she is probably from a specific socio-economic class, and the more we do this, the more that their personal worldview will come in. And it's interesting, having done the research you've done a lot of empirical research on this, that you come out still having quite a degree of confidence that judicial discretion can be used in this area, and that regulation is something we should be cautious about.
I think as it stands, and yeah, I think it's maybe more of a cost-benefit analysis of how much a regulation can accomplish over and above judicial discretion. But I think, yeah, definitely, I think that maybe more the view that I've come around to is the necessity of judicial discretion when you're dealing with party litigants and with lay people. And it's exactly because you just can't predict, and no rules could possibly predict. And that's something I think about, well, how much should we have more codification and really set out exactly if this happens and this happens and really have more guidance. But I think it's difficult because it's just so impossible to predict all the various sort of situations that you're going to run across. Again, particularly when party litigants are involved, particularly with, this is the thing about solicitors, is when a sheriff has or a judge has a solicitor in front of them, they know exactly what they're getting, and they know exactly what they can rely on, that knowing that they know what they're doing, that they're going to tell them what they need to know. And with a party litigant, they can't. And that is, again, why I think that there always has to be some sort of place for judicial discretion when they're dealing with lay people directly.
So, and last question, what's next? Are you going to write plain meaning rules or simple rules?
So that would be for somebody a lot smarter than me, I think. That's a big job, isn't it? I can't even imagine trying to put all that into what we have now into plain language.
Mm-hmm.
Oh, it'd have to probably be not 500 pages long, wouldn't it? It's terrifying to think about.
I always think you could turn it into a film. Yeah, a film, feature-length film. People would watch it. You could, anyway, but I don't think we have any more questions from social media, although we have had people tuning in. So thank you to those for tuning in online, and thank you to everyone for coming along, and a big thank you to Halle for a fascinating presentation and for kicking us off this year. And I should say that our next meeting is on, and I've lost it because I put it in my notes, is on the 26th of October, and we're looking at community benefit clauses in Scotland. So this is a thing that you find in England and in Scotland, whereby the government are putting clauses into their contracts which are requiring contractors to do things that are in the interest of the community. So we have Alex McTeer and Victoria Sutherland coming to speak to us again. They've done some empirical research on this about their impact and how or whether they are being effective. So you can join us then. For now, thank you very much, Halle.
Thank you. Thank you.